8 years on probation, a serious felony conviction, and now 5 violations that could send her straight to prison. In today's courtroom, one woman's past is catching up to her, and the judge has to decide if this is redemption or the end of the road. Stay with me.
All right, ma'am, you're Louisa Magruder.
Yes, ma'am.
And Ms. Magruder is currently on probation for sexual assault of a child in cause number 16-25158. Motion to revoke probation has been, or motion to revoke unadjudicated probation has been filed. And Mr. Bynum, do you have an announcement?
Yeah, if we could confer with the court perhaps, but if we, I mean, we're ready to plea not true and all of that, but I've been speaking with, this is my first time appearing on
Sure.
it. Ms. Magruder, if I can just introduce myself and why I'm here. And little known fact about Ms. Magruder is that she's actually one of the class plaintiffs in what is still the largest civil rights case related to bail in the history of the country, in federal court here in the Southern District. So she sued Harris County, the judges, regarding the misdemeanor bail practices. And I know her because I was one of the judges she sued. And but I agreed with her, which as a criminal lawyer, I don't have much of a conflicts practice, but this was a pretty funny one. The lawyers in that case called me and asked me to try to take care of her here. And what I say about being on an MAJ is that I'm the last to the party. You know, that everyone here has been here on the case for much longer than me. It seems to me that she's, she's 8 years into a 2-year probation and has put down many years of sobriety in there. She's responded successfully to ISF in 2020.
Let me stop you, because I guess just as far as kind of procedurally,
Yeah.
If there is, the way I'll handle all of the motion to revoke. So if there's an agreement, y'all can get that taken care of, do paperwork for whatever's going to happen. If there's not an agreement and you want to argue for me to do certain things,
Right.
then what I'd rather do is go through the motion, get pleas of true or not true, and then what I do is reset the case for a sentencing hearing. So everybody has time to provide whatever information they want, bring any witnesses they want. Probation will do an updated pre-sentence report that'll give me more information, and then I'll listen to all of that on that day.
Okay.
This is a critical procedural moment. The judge is explaining how revocation hearings work. First admit or deny the violations, then gather evidence, witnesses, and reports. Only after that does punishment get decided. Translation: this case just entered the danger zone.
Okay.
I understand. Could I just add where I was going with what I was saying? And I'm sorry I long-winded. I was wondering if the court would consider, she has a TRAS from last May that recommends substance abuse treatment. I was wondering if the court would consider, with the consent of the state, amending to safety.
So what would happen is I would still get an updated report, because I need to see what all if they agree to that, then yes, I will consider it. So if y'all have an agreed recommendation, yeah, she cannot go because of I didn't think her underlying offense. She's not eligible.
Judge,
So-
just still at the court. I don't want to interrupt.
No, please.
And the court knows the history with this, but
Yeah.
back in June of 24, we did where the court was absolutely will not accept the plea agreement on this.
Okay.
We're not gonna agree to anything because we've done this.
We've been here before. It's unfortunate that I recognized Ms. Magruder over the last few years, and so apparently I have.
We've given
So
twice. We've actually given it.
okay, so
Compliance.
Did you catch that? We've been here before. That's courtroom code for patience is running out. Multiple chances, multiple warnings. At this point, judges stop hoping and start preparing for prison time. Would you still believe in second chances after 8 years?
Strict, very strict compliance.
all right. So here's what we need to do then, based on that, just so that we can all get caught up, is get the pleas of true or not true to the allegations, and then reset it for a hearing. You can provide whatever you need, argue whatever you want, bring whatever witnesses. State can do the same. We'll get that updated report, and then I'll make a decision what to do. Okay?
Well, I'll enter pleas are not true.
So let's do this then. Ms. Magruder, please raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. And will your client waive the formal reading of the motion?
Yes, we will.
Okay. Let me get this pulled up. So, Ms. Magruder, in cause number 16-25158, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation January 29th of 2018 for sexual assault of a child, a second-degree felony, and that was a 10-year deferred probation. Is that correct? And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department on May 23rd of 2025 and to the administrative hearing on June 2nd of 2025. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 3 alleges that you failed to submit to alcohol and/or drug screening on June 2nd, May 28th, and May 19th of 2025. Is that true or not true? Count 4 alleges that you're behind in your court-assessed fees as of June 2nd, 2025.
Now we're at the heart of the case. 5 separate probation violations, missed appointments, no job proof, failed drug tests, nearly $9,000 owed, no treatment program. 1 violation is dangerous. 5 that's a legal nightmare. This is where freedom starts slipping away.
In the amount of $8,645. Is that true or not true? And then count 5 alleges that you failed to enter and successfully complete the Jefferson County Drug Intervention Program, JCDI, and that's from the order from September 24th of 2024. Is that true or not true? All right, so I will have pleas of not true entered for all 5 counts. Again, we'll reset the case for sentencing, and I will ask for an updated pre-sentence report. Obviously, anything that you think is important for me to know, get that information to Mr. Bynum. He'll present it to me on your behalf on that date. All right, we'll see you back on that date. Thank you.
The alleged offense date was what, December 5th? It's recent. So maybe that's why with closures and
I'll make a
holidays.
phone call and check with the detective this morning, Judge.
Okay. Am I thinking of a different one? Is this the one where the victim and the
This is the one
aggravated?
we started with the sexual assault trial and we got through and we couldn't get the victim to come back. There was a plea deal entered on the aggravated assault and a dismissal on that sexual assault.
Okay, this is a different one that I'm thinking of. As far as, I was thinking another murder. Okay,
Then
yeah, I'm thinking something different. Okay, got it. All right, so you're Thaddeus McCray,
yes, ma'am.
and Mr. McCray is currently on probation for aggravated assault causing serious bodily injury. A motion to revoke has been filed. Obviously, the main allegation is the new offense of the alleged murder. And it's my understanding that it has not been indicted yet. What I'm going to do is one more reset on this motion. Mr. Smith, I know it's only been less than a month, I guess. Well, a little over a month. If you'll please get with intake and
I'll try to find a timeline on this.
figure out when, and if you'll let us know that, but I'll do one more reset. But if it's for some reason there's some issues, I can't just keep holding this for that. So this will be the kind of the last reset on the motion without some specific information of what's going on that murder case. Okay,
Yes, ma'am.
perfect.
Thank you.
You can go back with the bailiff, sir. Hopefully soon Ms. Perazo will find out what the status of the murder case is. Once it gets indicted, she'll get all that information. Then we'll see where we go with your cases. Okay? All right, you can go back with the bailiff.
And just like that, the focus shifts from probation to a possible murder charge. No indictment yet, but the clock is ticking. Once that paperwork drops, everything changes. Bail, bond, probation, none of it may matter anymore. In this courtroom, the future is always one document away.